Good evening and welcome to Supreme Court Observer's live daily updates. I'm R. Sai Spandana, an associate editor at SCO. Today we continue our update on the plea for marriage equality before the CJI-led Constitution bench at the Supreme Court. Today was day 5 of the arguments before the bench. The bench had originally intended to conclude the petitioner's side of the arguments by 11:45 today, but that did not happen. The petitioners argued for the first half of the hearing before lunch, and Solicitor General Tushar Mehta, representing the union government, argued after lunch. Today's arguments were commenced by Advocate Karuna Nandi. She essentially argued that she sought a declaration by the Supreme Court to include the rights of queer, non-heterosexual couples right to marry under the Special Marriage Act and the Foreign Marriage Acts. She stated that the Transgender Protection Act of 2019 already recognized a wide range of gender identities and trans marriages. The word third gender spouse was used in this act, and this act was a direct result of the Navteej Singh judgment of the Nalsar judgment of 2014. Therefore, the words used were not coincidental or by chance in any way. The phrase third gender spouse has since grown and evolved to include the word non-binary spouse, as it faced some criticism by members of the trans and queer communities. Therefore, the provisions of the Special Marriage Act and the Foreign Marriage Act must be where the words husband and wife are referred to, they must be replaced with non-binary spouse. They must be replaced to include the phrase non-binary spouse as well. Justice Butt questioned Ms. Nandi over here. He said that her predecessors, the other advocates who argued for the petitioners, sought for the words spouse to be included in the Special Marriage Act and not the phrase non-binary spouse. However, not much was said on this topic after that. After Advocate Karuna Nandi, Advocate Arunati Karju appeared for the petitioners. She started her arguments by acknowledging the fact that the question before the bench was very, very complex and not one that could be solved in a single day. She attempted to answer some of the questions raised by the bench yesterday. Yesterday, Justices Butt and Chief Justice D.Y. Chandrachud had asked Ms. Dr. Menaka Guruswamy to what extent the courts could get involved in this matter, as the canvas of petitions before the court inevitably involved personal laws, and the legislature had authority over the subject matter of these petitions. Ms. Karju said that she sought a declaration from the court that had two aspects, one positive aspect and one negative aspect. The positive aspect was for the court to issue a mandamus to the state to recognize LGBTQIA plus marriages by law, and the negative declaration was a prohibition. That is a prohibition that the state cannot discriminate on the basis of sex and gender identities. She also shed light on the adoption laws, and she stated that the point of adoption was to provide the child with a stable and loving family, and there is absolutely no reason to believe that LGBTQIA plus couples could not provide that to a child. She went on to argue that regardless of whether or not the law recognized the adoption rights of LGBTQIA plus couples, many of them did have children, and the rights of a child flowed from the right to marry. So by not recognizing the LGBTQIA plus couple's right to marry, essentially the rights of the child is also denied. And this leaves the child in a very vulnerable position, as his rights are not recognized by the laws of the country. After Ms. Karju, due to the paucity of time, the remaining advocates appearing for the petitioners made very, very brief submissions. Advocate Amrita Nanda Chakrabarti appeared. She shed light on the adoption regulations of the country and how they forbade not only married queer persons and trans persons, but also unmarried. Like, if a queer couple was living in together and were not married, even a single person was not allowed to adopt under the laws of the country, and she claimed that this was extremely discriminatory and must not be allowed. The point of adoption laws was to provide the child with a stable, loving and affectionate family, and LGBTQIA plus couples could provide that for them. Next, advocate Shivam Singh appeared. He shed light on the concept of innateness. He stated that when something is so innate and essential to a person that it forms a part of their identity, the state cannot use that innateness as a yardstick to make laws that are discriminatory in nature and that disadvantage that person. And gender identity and sexual orientation was part of this innate identity of LGBTQIA plus persons. Therefore, to not recognize their marriage rights and other rights by law was discriminatory by this yardstick of innateness. Next, Mr. Srinath also appeared. He stated that the court had the power of judicial review, and when the parliament enacted laws that were discriminatory in nature and they violated fundamental rights of the citizens, the Supreme Court was duty bound to step in and make the necessary corrections there. After the petitioners completed their arguments, some interveners also appeared on for the petitioners. They made very brief submissions and submitted other arguments through notes. And after lunch, Solicitor General Tushar Mehta began arguments on behalf of the union government opposing the marriage equality pleas. Firstly, Mr. Mehta reiterated his argument made on the first day of the hearings. He said that this was a matter that fell under Parliament's power because, firstly, it concerned, the marriage laws concerned at least 160 other statutes, related statutes. When there is a change in the law that is sought by the petitioners, it inevitably affects all these 160 statutes. Secondly, the LGBTQIA plus is a class of persons whose gender identities are not entirely defined. For instance, the plus in the LGBTQIA plus included in it at least 72 other shades of gender identities on the gender spectrum. Therefore, when laws had to be made for an unidentifiable and undefined group of people like this, and they involved a lot of other statutes in connection, then it was Parliament and not the court that had the power to legislate and form laws on this matter. He stated that there was obviously no doubt that there could not be discrimination on the basis of sex, sexual orientation, gender and gender orientation. This was clearly established by the Supreme Court in judgments like Navteej Singh Johar in 2018, where homosexuality was decriminalized under the IPC. However, when it came to formulating laws or making changes to enactments, then it was Parliament and not the judiciary that could take the call in the matter. He also shed light on the dissenting judgments by other countries that the petitioners had relied on cases like Obuchi-Fell, for instance, to claim that other countries such as the US had already recognized LGBTQIA plus marriages. Solicitor General Tushar Mehta focused on the dissenting judgments of these cases to further his claim that the legislature was the appropriate authority to frame laws on the subject matter and not the judiciary. Next, Mr. Mehta argued that the intention of the Special Marriage Act when it was drafted was to recognize the union between a heterosexual man and a heterosexual woman. In this regard, he also rebutted an argument made by Mr. Rohatgi on the first day. Mr. Rohatgi had claimed that, of course, the Special Marriage Act did not account for same-sex or queer marriages when it was created because the concept did not exist back then. It is a relatively new concept that has evolved over time, and the Constitution recognizes this right to choice and right to privacy, etc. However, Solicitor General said that that was not true. For instance, while considering the grounds for divorce at the time, the framers of the law did contemplate replacing the word sodomy with the word homosexuality. So they were aware of the concept of homosexuality back then, and they consciously made an effort to not include that in the provisions of the Special Marriage Act. He read out many speeches by parliamentarians at the time who were involved in the debates behind the Special Marriage Act to claim that though the drafters were aware of homosexuality as a concept back then, they made a conscious choice to not recognize it in the Special Marriage Act. Therefore, it was the intention of the drafters of the Special Marriage Act back then was to recognize interfaith and intercaste marriages of heterosexual couples and not homosexual couples. So no matter what interpretation the court does, it cannot go beyond this original intention of the Special Marriage Act. The solicitor will continue his arguments on behalf of the Union government tomorrow. And that wraps our live session today. Stay tuned to SCOobserver.in for all latest updates from the Supreme Court and all the latest updates concerning the plea for marriage equality. We will see you tomorrow. Thank you.